Good morning, good afternoon, good evening, depending upon where you are in the world. My name is Leila Sadat. I am the chair of the American branch of the International Law Association. I'm also the chair of the study group on crimes against humanity. And I'm really grateful to all of you for being here to hear this update on what happened in January at the Preparatory Committee meeting for the Crimes Against Humanity negotiations. And I'm also really grateful to ABILA and particularly Freya and Julia, who have really supported the work of the study group and have helped organize this webinar. As many of you know, it has been more than 80 years since the Nuremberg trials and the Tokyo trials happened in the wake of atrocities committed during World War II. And you also know that after those two wars and after those trials were held, the United Nations, which was then newly established, codified the crime of genocide in a treaty after a General Assembly resolution, and also codified war crimes in 4 Geneva Conventions. But what was never codified after the war was the crime of crimes against humanity, which is what was actually included in the Tokyo and the Nuremberg charters as the incrimination under which the Nazis and the leaders of the Axis power were indicted. And so many decades later, we are now on the cusp of actually negotiating a new global treaty on crimes against humanity, thanks to the hard work of so many individuals who have been involved in this process, from academics to international judges to practitioners of international criminal justice, and of course to the states who are in the General Assembly and who have been working assiduously on taking this process forward. Many of you may know that in 2024, a General Assembly resolution was adopted, Resolution 79/122, which set out a 4 or 5, depending on how you count it, year process for the negotiation of this treaty. We had perhaps wanted something that would happen a little faster, but that was the resolution that we got. And the first major step in that resolution was the convening of a preparatory committee that would meet alongside a working group in order to take the draft articles that had been developed by the International Law Commission and published in 2019, discuss them, debate them, not negotiate them, but simply discuss, and also decide on the possibility of civil society participation being expanded during the next preparatory committee meeting scheduled in April of 2027, and the diplomatic conference itself, which will take place in 2028 and 2029. Here to discuss both the process of these negotiations and the substance of the draft articles are some extraordinarily qualified individuals. I won't spend a lot of time on their biographies. You know them well. Professor and Dean Olympia Bekou is the Dean of Nottingham Law School. She attended the January PrepCom. I think all of us actually were there, except perhaps Tom, who attended from afar. And she is the Dean of Nottingham Law School. She's been deeply involved in this process from before actually even the development of the ILC draft articles in 2019. And she's an expert on international criminal law, human rights, and global justice. After that, we'll hear from Professor Tom Dannenbaum. He's been a distinguished member of our study group. He's now a professor at Stanford. I first got in touch with Tom when he was at Tufts University. I think, Tom, is where you were before. And he has also been a member of the study group, and I should say has elaborated really and participated, particularly with respect to the crime of starvation, but many other things as well. After that, we'll hear from Mr. Youssef Hitti, who's the legal advisor of Lebanon to the United Nations. Youssef has been amazingly involved in this process from his perspective as somebody involved in the negotiations and a state participant, and he'll be able to give us some idea of what states are thinking as they look forward to the preparatory committee. Followed by Christopher Lentz. Chris is now with the Register of Damages for Ukraine. He was also a distinguished practitioner at the ICTY and has held many other positions in international law, particularly international criminal justice. Like Dean Bekou, Chris and Olympia have both been members of the study group and the drafting committee, which has produced many proposals. And we'll put a link to the study group work in the chat so you can all see it. And finally, last but certainly not least, is my friend, co-conspirator and a gender expert, Akila Radhakrishnan, who's actually coming to us from California today, I think. And Akila also attended the Preparatory Committee meeting in January. She has been deeply, deeply involved in this project since before the publication of the final draft articles in 2019, and will give us, as sort of concluding remarks, a roundup of sort of where we are on both gender competency, gender expertise, and gender parity with respect to the negotiations. So I know we're in for a really rich discussion today, and we look forward to not only hearing from our panelists, but hearing from you, our participants. If you have questions, feel free to put them into the question function. I can see them. And in general, we'll have a first round of all the panelists. Then the panelists will have an opportunity sort of to come back to each other if there's anything that they want to discuss in addition. And we'll work in your questions as we see them. So don't be shy and don't hesitate. So without further ado, I'd like my good friend and colleague, Dean Olympia Bekou, to kick us off. Olympia chaired the drafting committee for the study group and has been deeply involved in the work of this Crimes Against Humanity Treaty's elaboration for decades, almost as long as I have, Olympia. So now I'll turn the virtual podium over to you, and thank you so much for being here.
Thank you, Leila, and thank you to everyone for joining us for this webinar. As Leila said, I've had the privilege of chairing the drafting committee of the ABILA Study Group on Crimes Against Humanity. So first and foremost, I would like to acknowledge the subgroup authors for their amazing contributions. Without them, the proposals that you would have seen or that you will get in the chat would not have been possible. So I have been asked to talk a little bit about how to make this convention effective. So I would start by saying that the value of the Crimes Against Humanity Convention will not be seen at the point of its adoption alone, but in its effectiveness in practice. Therefore, it is important that the convention does not become a merely symbolic document, but that it functions as a robust and enforceable instrument, with the goal of having a convention that is workable, effective, and meaningful. My focus today will be on some of the prevention and capacity building dimensions of the draft convention and the possible establishment of a treaty monitoring mechanism. So the convention, as you may have seen, places strong emphasis on both prevention and prosecution. Prevention lies at the heart of the proposed convention and reflects a fundamental principle of international law. Crimes against humanity must not only be punished, but also prevented before they occur. So prevention, however, is not a passive obligation. Under Draft Article 3, states must be vigilant and proactive, ensuring that their conduct does not contribute to the commission of crimes against humanity. The ABILA proposal expands that to include omissions and also expand not just to direct, but also indirect contributions to the commission of those crimes. States carry the primary responsibility for prevention through domestic action. And again, the ABILA group further proposed enhancements to Article 4 to further operationalize this duty by including an obligation to suppress such crimes, emphasizing that states must act not only before crimes occur, but also intervene in situations of serious risk of ongoing harm. Carrying out these preventive measures effectively depends on having a legal system in place and the capacity to do so, which is why it comes it comes as an important point next. The building capacity at the national level is very important and I would say indispensable. So if you don't have the resources, expertise, institutional support, even the strongest preventive laws and obligations cannot be implemented. So during the PrepCom in New York, which, as Leila said, I've had the privilege to attend, several delegations brought up this issue. And I'd like to refer here to Bangladesh, Nigeria, Sierra Leone, Sudan, Timor-Leste, Zimbabwe, amongst others, who all raised the critical importance of capacity building in their statements. It is only through capacity building that states can empower the national jurisdictions to effectively implement preventative measures. So I share their view that enhancing national capacity is central and core to the preventive objectives of the Convention. And more broadly, I would argue, to its effectiveness and long-term success. Having worked on capacity building in multiple countries across the regions of the world, I can also attest to the fact that every state faces limitations. No country has unlimited resources, particularly in the current climate. While some face greater challenges than others, common challenges include physical and human infrastructures, which may be limited, insufficient expertise or training budgets, and competing policy priorities. So an important next step in my talk today is the how. How can we facilitate capacity building? Specialized training and institutional development are essential to effective prevention. Domestic law authorities may lack the knowledge, skills, and technical expertise required to identify early warning signs, assess risks, and take action before crimes against humanity occur. So this is a challenge that is often exacerbated by overwhelming caseloads, limited resources, which further hinder investment in training and infrastructure. However, both are crucial for preventing crimes against humanity. Consequently, it is essential to provide specialized training for law enforcement and other relevant personnel. At the same time, strengthening institutions to ensure that the infrastructure exists to support the consistent application of preventive measures. So when it comes to capacity building and the new Convention on Crimes Against Humanity, I would say that we should not reinvent the wheel. As this convention intersects with human rights treaties and draws inspiration from other international criminal justice instruments, there is already plenty of experience, expertise, and lessons learned that can be leveraged to enhance capacity building efforts. So capacity building must be strategic, coordinating, using existing expertise and resources to develop a more cohesive and efficient approach. International organizations, as well as civil society, can play a leading role in this process, encouraging and assisting states where needed, helping them to fulfill their obligations, and sharing expertise and best practices to enhance efficiency for this new convention. But that requires coordination. Coordination among competing capacity building providers and their agendas that sometimes is hard but essential, but is needed to optimize the use of already limited resources and prevent an overlap or duplication of activities. So I would argue that we also need a credible, expert-led monitoring mechanism for the convention, composed of independent experts in order to assure the treaty's effectiveness. The creation of such a mechanism, a treaty monitoring body, has been supported by some delegations, including Sierra Leone, during the PrepCom. The ABILA Study Group has also got a very extensive proposal on the treaty monitoring mechanism, which I would invite you to have a look at. What the study group has proposed is a mechanism that has 3 interlinked organs: a conference of states, a committee of experts, and a secretariat, supported by a voluntary trust fund to assist states with capacity building and implementation of the convention. Even if non-binding, such a mechanism can provide valuable insights and essential support for prevention. A robust monitoring system would not only ensure compliance and transparency, but will also identify early risks and recommend corrective actions before violations occur. For example, the monitoring mechanism could include measures such as early warning systems to detect potential risks of non-compliance at an early stage. Without such a mechanism, the treaty risks remaining weak, relying solely on states' willingness to comply. But beyond oversight, the mechanism could also actively support states in implementing their treaty obligations. The Conference of States Parties that we have in the proposal and the committee could perhaps coordinate specific capacity building initiatives, including legislative support, facilitate exchanges of successful practices, and provide tailored technical assistance, such as training programs, toolkits, manuals for law enforcement and judicial officials. And the trust fund would further enable states, particularly those with limited resources, to build institutional and administrative capacity by creating such a platform for states to exchange technical, financial, and legal support. So the ABILA proposal that you have before you draws inspiration from already established bodies that monitor the implementation of other conventions, such as Human Rights Committee, the Committee Against Torture, or the Committee on Enforced Disappearances. By institutionalizing similar functions, the Convention on Crimes Against Humanity would establish a concrete and operational framework capable of assisting states in fulfilling their obligations and strengthening the prevention on crimes against humanity. Let me conclude. I talked about a little bit on prevention, capacity building, and the treaty monitoring body. This is because I think that by taking proactive measures, strengthening national capacities, and supporting a robust monitoring framework, we can transform this convention from a legal text into a practical tool that effectively prevents crimes against humanity. And only then can we ensure that this convention is not simply adopted, but it becomes fully operational and is implemented effectively. Thank you.
Thank you so much, Olympia. That was just wonderful. And I think for our audience participants, you can understand that the basis of the negotiations is a combination of a 2019 text that emerged from the International Law Commission. And in addition, now states have the opportunities to submit proposals by April 30th. And so what the ABILA Study Group tried to do is look at the 2019 draft and say, where might the draft be further enhanced, either in promoting effectiveness and promoting implementation or in filling gaps? Because of course, the International Law Commission had a very different brief than states will have when they actually go to negotiate this draft treaty as partners with civil society. So one of the things we're doing is we're putting in the chat some of the references to some of the proposals that are there as a sort of academic expert offering to states as they continue through this process. All right, so our next speaker is Tom Dannenbaum. Tom, I'm going to turn over the virtual podium to you so you can tell us a little bit about your work and the starvation proposal and whatever else you want to speak about today. Thank you.
Thanks very much, Leila, and thanks for your leadership on this and for the overview that you've provided today. And I just want to echo Olympia's points about the imperative to make sure that this is a functional and practically effective treaty. And many of the components that she laid out are absolutely critical to achieving that objective. I want to zero in on the question of Draft Article 2, the question of the substantive definition of crimes against humanity, and particularly thinking about expanding the enumerated acts listed in Article 2 to encompass additional crimes that are responsive to contemporary values and challenges. There is obviously a reticence within at least some component of the community of states that are engaged in this process to do that. And in a sense, that's understandable. We're at an extraordinarily challenging moment in international law. Powerful states are engaging in brazen violations and equally brazen attacks on international institutions and agents of accountability. And we're talking about an enumerated list that was developed at a moment that looked much more promising for international criminal law. That the list that we have in Draft Article 2 being derivative of the definition of crimes against humanity in the International Criminal Court's Rome Statute. So there's an understandable inclination to cling on to what we have. But I think that would be a mistake, and I think it would be a mistake for a number of reasons. First of all, if we're to emerge from the current, what I think is aptly characterized as crisis in international law, it's not going to be by seeking to return to what we had before the crisis. It's going to be by offering a compelling, positive, normative vision of what international criminal law can and should be, and that it needs to be responsive to contemporary challenges and concerns. And there is sufficient energy within the community of states to achieve that objective. We can see that energy in part in the pushback against the assault on international law and international institutions, which manifests across multiple dimensions, whether it's multi-state referrals to the International Criminal Court, whether it's third-party public interest litigation at the International Court of Justice, or the increasing sophistication and elaboration of transnational cooperation mechanisms, investigative mechanisms, joint investigation teams, the Ljubljana, the Hague Convention, ad hoc coalitions seeking to pursue accountability in particular contexts, not to mention the activity of civil society in seeking to activate and operationalize universal jurisdiction systems in states where they have thus far been dormant, in addition to drawing on cutting-edge technology and open source investigation. So there's a tremendous amount of energy notwithstanding this challenge to international law in this moment. And it's really important to harness that energy towards a vision of international law generally and international criminal law specifically that is inspiring and that leads us out of a moment of crisis into a more progressive vision of international criminal law. And with respect to the specific issue of opening the list of crimes against humanity, it's crucial to remember that crimes against humanity, unlike some other criminal categories, has always been a category that is overtly open to evolution and development. That's been true from the very beginning, with the codification of other inhumane acts as a residual category going all the way back to the charters adopted in the aftermath of World War II that Leila referenced earlier that underpinned the prosecutions at Nuremberg and Tokyo. And that's been in constant iteration with updated codification through new statutes over the course of international criminal law's development. So it is, of course, apt, 30 years on from the Rome Statute, to think today about whether the list that we have is apt to existing challenges and contemporary values. And there are many dimensions on which one could argue for new codified crimes. And I think we're going to hear about the environment and gender later in this discussion. But I'll just focus specifically on the issue of starvation. And I think there are a couple of reasons why we have to take this really seriously as an issue that requires distinct and specific attention. First of all, the scale of the harms that are being inflicted through this particular method, in other words, the deprivation of indispensable objects to civilian populations. And secondly, the nature of those harms. So if we think about the scale, 318 million people globally suffered acute food insecurity at crisis or worse levels last year. That's a threefold increase on a decade earlier, and it's 24 million more than just the year before. 41 million of those are suffering at emergency levels of acute food insecurity, in other words, one step from famine, and the Famine Review Committee of the Integrated Food Security Phase Classification System has identified famine in both multiple areas of Sudan and Gaza in the last 2 years alone. These are not only catastrophic absolute numbers, it's a catastrophic trajectory. And it's not just about the scale of the harm, it's also about the kind of the harm. It can't simply be reduced to elevated mortality. What scholars of famine have shown over and over is that famine inflicts not just elevated mortality, which is of course of critical concern, but also profound social and individual destruction. What in my academic work I've called societal torture, as individuals' biological imperative to be free from extreme suffering tears against their capacity for higher order social, political, and familial commitments in a way that destroys societies, that inflicts what social anthropologists have called the accordion effect, whereby the web of moral concern contracts as societies turn in against one another, with not just immediate destructive effects, but transgenerational and lasting effects. So both in terms of the nature and the scale, this is of profound concern to the international community. And these effects are not simply the result of intractable scarcity or the inevitable consequence of climate change. They're the product, in many instances, of deliberate decisions to deprive civilians of objects indispensable to their survival as a means of coercion, subjugation, and achieving belligerent objectives. It's important to then channel those two components, that scale and the nature of the harms, into thinking about why it's essential to enumerate this crime explicitly and distinctively. And there are two key reasons for doing so. One is expressive and the other is practical. And both of them then inform how we can see why the existing enumerated lists of crimes against humanity isn't sufficient to address this specific concern. We do, of course, have enumerated acts that are relevant: extermination, murder, persecution, and other inhumane acts. But extermination and murder are derivative of lethality, so they capture only a small component of the wrongs inflicted through this method. And additionally, in a context of stretched temporal nexus and crowded causal context, they can be difficult to establish evidentiarily. Persecution often will apply, but it's contingent on a discriminatory animus that may or may not be present and that may be difficult to establish evidentiarily in particular contexts. Other inhumane acts offers therefore the most propitious path, but it's expressively thin in terms of its ability to properly capture the nature of the harm. And crucially, in a context of a treaty that's supposed to inform agents of accountability across multiple jurisdictions, applying multiple different frameworks of legal interpretation, it doesn't provide the level of action guidance and empowering of those agents of accountability that's necessary for them to actually pursue accountability for this specific wrong. So the definition we've suggested in our draft article would be one among many possible alternative options for pursuing this criminal category in a way that is expressively apt, practically implementable, and responsive to the scale and the nature of the harm associated with this particular form of human suffering. So I'll pause there and hand it over back to you, Leila.
Thank you so much. I just cannot express enough and strongly enough how impressed I am every time I hear you speak. And every time I hear you speak about this particular issue. And as you can hear from the two speakers thus far, one of the things that's ongoing with looking at the 2019 draft is some of the proposals that we worked on strengthen the architecture of the proposed treaty, right? They'll reinforce capacity building, they'll reinforce dispute settlement, they'll reinforce prevention. Eventually, there'll be something about reservations or not, right? Things that go to the architecture of the treaty. Others are about looking at the normative content of the treaty. And I think Tom's intervention there on why we need to look at this as a 21st century instrument that can exist not just for today, but for the future is so important. We couldn't include everybody in the webinar. There are 14 papers. We have a paper on children. We have a paper on slavery and the slave trade. We have papers on civil society participation. That fortunately was very effective, thanks to states in January. But I encourage you to look at all of the papers, and there'll be a second iteration at the ILA level where we'll look at some of the other issues as well. All right, now I'd like to hear from Youssef Hitti to talk about the state and the state perception and how states are seeing this process. And Youssef, you've been so deeply involved in it. We're really excited to hear your reflections. Thank you.
Thank you so much, Professor Sadat, and hello to everyone. And let me start by actually saying that I think today's discussion, bringing together diplomats, academics, civil society, I see students as really reflects the kind of inclusive exchange that can meaningfully support this process. So these platforms very much matter. They foster engagement, they deepen understanding, and they contribute to building trust. And this will be very useful as we're all now gradually moving toward the negotiation phase. And as you said, having myself been closely engaged in the 6th committee discussion since the draft article of the ILC were finalized and transmitted to the 6th committee in 2019, yeah, I can tell you that we have indeed come a long way. From the outset, my delegation, of course, I was not the only one, but my delegation has really stressed that process matters almost as much as outcome, if not as much as the outcome. And particularly as I think Olympia Bekou referred to, we're not talking about just any convention. We're discussing what is supposed to be a defining convention of our time, right? So the objective, of course, would be to elaborate and conclude a robust, effective, and universal convention. And also because also it was, I think Professor Dannenbaum alluded to it, that this process is happening as mass atrocity crimes continue to be committed. And for some of us, unfortunately, and speaking as a representative of Lebanon, we know very well what is at stake. So it's against this backdrop that I'd like to offer some reflections, not exhaustive one, but limited reflections. We'll start with the PrepCom that has just concluded right now in January. And I would characterize it as serious, substantive, and focused. The atmosphere was generally constructive. You were there. Engagement across all clusters was meaningful. You saw that delegations framed their positions with greater precision. Some clarified longstanding views. Some delegations also probably prefer to still listen carefully before fully engaging. They want to hear the range of views first. And this is a normal feature of multilateral processes. You have those who are in listening mode and waiting mode. So, and of course, it's clear that you still have delegations that approaching the draft articles from different perspectives. Some seeing it as a starting point on which to build and improve. Some not necessarily seeing them as a baseline and may wishing to revisit some fundamental aspect. Also, something that is worth noting to me that we've seen a number of delegations already making textual suggestions on the draft articles, which for me already is signaling and indicating that there's this move toward the negotiation mindset. And one last thing on the format, also had present the special rapporteur on the topic, Mr. Murphy, who introduced the different clusters and also responded to questions from state regarding the methodology and rationale underlying the drafting of the provisions. And I think this allowed these delegations, to seek clarification, and it was probably much needed. And for those of you who know a bit about this whole discussion on enhancing the interaction between Sixth Committee and ILC, that was seen as an enhanced dialogue in practice, in a way. So you mentioned, Leila, that now, where there will be a submission of proposals by the 31st of April. So just so everyone know, probably you already know, but not all states will submit proposals. And there are various reasons for this. Capacity constraints. Sometimes you also have complex internal approval procedures, or also what I said earlier, the preference to first review proposals submitted by others before presenting their own and refining maybe their own views. This is how some delegations can operate, by listening first. So what do we do and where do we go from here, right? So I believe intersessional engagement and outreach will be critical to keep the momentum and ensuring broad participation, regardless of position and views, right? We need to be as inclusive as possible. I really believe that creating conditions for wider participation at every stage is essential, particularly for smaller delegation, where the same legal advisor may cover multiple processes. And this is my case, but not only my case. As most of you know, for instance, today we have a PrepCom on BBNJ that started. PrepCom seemed to be in style. I don't know why. You also have protection of person in the event of disaster with a working group and a conference scheduled next year. I'm saying this because, moving forward, we must be mindful of these multiple processes. When we coordinate, we need to have realistic timelines and adequate preparation. This is important to avoid this overload, especially for smaller delegation, but not only a smaller delegation. And the forms of engagement, the way I see it, is first participatory, like we're doing now, CSOs, academia, diplomats, briefings for new delegates. You'll have new delegates between now and maybe this summer and next year arriving. So we must have briefings. We can have retreats and workshops on areas of divergence, on some thematic discussion. That can happen. Also, what ABILA typically is doing in generating ideas and textual proposals, this is extremely valuable. Not because state must endorse them wholesale, but because, you offer concrete language and it sharpens analysis. It gives us something tangible that we can react to, that we can adjust, and that we can, as well, what I said, refine. So this, having these like materials being produced is always very important to us. And something that I will add, and Professor, you know how important this is to me, but not only to me, is the multilingual dissemination of these materials. And as you know, in our conversation, I always say that it's very important that, I personally very much welcome, all these documents, and I welcome that a lot of them are actually translated in French, Spanish, Arabic. I think this is quite useful, quite valuable, particularly for treaty making processes. So yeah, I'll stop here by just saying that yes, we've come a long way since 2019, and we still have a long way until 2029, and looking forward to continuing this conversation and hearing your comments and questions. Thank you so much.
Thank you so much, Youssef. And j'ai honte un petit peu. I'm going to say that we have a French translation and a Spanish translation of our draft that Chris prepared, but I am the holdup because I have to proofread the French and I haven't done it yet. But I suppose we could just post it and say unofficial and unproofread, and at least it would be available. And so one of the things that ABILA did do is we did create an English language version just of proposal amendments. And we've now translated it into French and Spanish, but I am actually the blocking agent here right now. So you have embarrassed me into getting this done, Youssef. Merci beaucoup. And I will get it done today. All right, we're now going to turn to Chris Lentz, who is going to give us his view from The Hague and also as a member of the drafting committee and the leader on many of the proposals. So Chris, it's now turning it over to you. Thank you.
Thank you very much, Leila. Good evening, good afternoon, good morning. I have to start by saying that although many colleagues on this webinar know that I attended the PrepCom as the delegate to the International Union for Conservation of Nature, I am speaking solely in my personal capacity, something I always have to find a way to slip in at the beginning of any discussion like this. But I'm going to focus primarily on some of the discussions and the extent to which we saw state support in terms of adding an environmental component to the forthcoming conventions. And what we really saw at the first session of the PrepCom in January was states continuing their leadership on this question, including consideration of adding environmental destruction or another type of serious environmental harm to draft Article 2 to the enumerated crimes against humanity that Professor Dannenbaum spoke eloquently about just a few moments ago. And all in all, what we're seeing so far is substantial momentum towards recognizing that environmental destruction can be, and in fact deserves to be, and maybe even more must be, recognized as a way in which perpetrators can act to harm a civilian population. In other words, we're seeing that environmental destruction, not as a means of environmental destruction itself, but as a means of harming a civilian population, is an aspect that states are increasingly continuing to advance in their discussions. So by way of quick background, this has been a state-led process. States have been at the forefront of this since the beginning. And it's really essential, in my view, to give credit where it's due. The first states to have raised the need to add an environmental component to the forthcoming conventions were Burkina Faso, Cameroon, Eritrea, and Sierra Leone. And they noted this, the need to have this first before the Sixth Committee in October 2023. They were soon followed by Ethiopia and by Morocco, subsequently joined by Cote d'Ivoire, Niger, Nigeria, the Philippines, and Togo, and ultimately complemented by Vanuatu, who delivered a powerful statement before the Sixth Committee in October 2025, highlighting the need for environmental destruction to form part of the eventual convention. So before we've even reached New York, before we've even found our way to the PrepCom in January, already a dozen states have recognized and vocalized their support for adding an environmental aspect to the forthcoming convention. But what will this environmental aspect look like? Well, that was unclear. And alongside states' calls for this component to be included, the IUCN prepared the initial proposal for environmental destruction to be recognized as an enumerated and standalone crimes against humanity. This was a narrowly tailored exercise that drew directly from Article 1 of the ENMOD Convention, the convention prohibiting the use of environmental modification techniques in war. Why this convention? Because it's well regarded, it's been championed by the General Assembly, and it already features an impressive cross-regional section of 78 states parties. The ABILA Study Group, in the proposal that I expect is on the side right now, streamlined this proposal a little bit further, maintaining most of its elements, but also adding some further definition as to what sorts of environmental targets could be expected when there's a widespread or systematic attack that's directed against a civilian population. And this is the background when we get to the PrepCom itself. At the PrepCom, 8 states, in addition to the African group, 54 states and 3 permanent observers, vocalized their support for adding an environmental component in the future convention. Some states called for that environmental component to look like the exploitation of natural resources, but the lion's share of statements focused on environmental destruction or serious environmental harm. Adding all this up, we have 59 states, nearly a third of states who have already expressed their support for an environmental component. And importantly, this coalescing global movement is comprised of states from the West and from the East, from the North and from the South, from countries that are considered developed and those that are considered developing. And it includes states that not only have experienced peace and prosperity in their recent history, but also those who have firsthand experience of suffering through crimes against humanity and know exactly what steps perpetrators can be expected to take in order to harm a civilian population. Lots of state support, no state opposition expressed whatsoever, other than potentially that referenced by Professor Dannenbaum in terms of the states who have a more principled desire to maintain Article 7 of the Rome Statute in draft Article 2. So many of those states, by the way, should be noted, are themselves champions of environmental causes amongst international law. And it can be expected that if there's a desire to open up draft Article 2, that there will be further state support for adding an environmental component. This is not ecocide. It's important to note that there is a corresponding ecocide proposal as the 5th international crime at the ICC. However, that proposal is non-anthropocentric. It is a harm to nature. It is a crime against nature, full stop. Whereas the proposals and the discussions that have taken place at the PrepCom and before are focused on destruction or harm to the environment as a means of harming civilians. And this really sets it apart. It's also an aspect that is tragically foreseeable, not only in today's world, but also as we seek to respond to contemporary challenges and concerns, as one of my colleagues here has already described. We can see that the global population continues to increase exponentially. We continue to rely on increasingly scarce natural resources, and those resources are themselves becoming more limited due to overuse, due to climate change, and due to weather extremes. And one final point to note is that a quarter of the world's population, 24%, are aged 14 or younger. And this is not only a once-in-a-generation opportunity for those on this webinar to create and to craft and to facilitate states as they negotiate a forthcoming convention, but also to ensure that the eventual convention is suitable not only for our generation, but also for many generations to come. So in conclusion, we can be optimistic. States have initiated the desire to add environmental components to the convention. States continue to champion this initiative, and it will ultimately be through states' leadership that we can expect to see an environmental aspect incorporated in the forthcoming convention.
Thank you so much, Chris. And wow, what a statistic. Thank you for sort of bringing that to our attention, that this is about current and future generations as well. One of the things I'll just add before turning the podium over to Akila Radhakrishnan is, as many of you have heard, the basis upon which the International Law Commission drafted was Article 7 of the Rome Statute, which codified in 1998 a definition of crimes against humanity. And so the question now is whether to rest with that 1998 definition codified then, or to understand that crimes against humanity have evolved in the last 26, almost 30 years by the time the treaty is negotiated. And environmental harm is one of the areas in which I think we've seen a huge corpus of now jurisprudence saying that the right to a healthy environment, to a sustainable environment, is a human right. And so we've actually put in the chat also a blog that I did that kind of went through the step-by-step about how the new treaty could crystallize essentially a developing norm of international law. Now I'd like to turn the podium over to Akila Radhakrishnan, who will give us the gender perspective. And Akila, you might answer. I know there's one question about gender apartheid already in the chat, so perhaps you could respond to that in your remarks. Thank you.
Thank you. Thank you so much, Leila, and thank you to everybody else. I think I have the easy task because I kind of can summarize a little bit where the themes that have come from. So I'm going to focus on gender, but through two lenses that I think others within this webinar have elaborated on. The first is really the importance of taking a structural approach towards this, and that applies to gender, and I'll talk a little bit about why. But Youssef, you really mentioned that the process is just as important as the substance itself. And I think that for gender, we really will be thinking about, and the paper goes into this, is really about how to set the process up for success for the negotiations of complicated issues like gender. The second piece is really, Chris, where you ended, about the opportunity here. You know, Tom was talking about how there's a need to reflect contemporary forms of harm in order to make this relevant. But we also need to think about the fact that this is a treaty for the next 50 years. It's a treaty for the next 100 years. So as we negotiate something in a moment of crisis and in a very difficult moment for any sort of multilateral negotiation, we need to keep that longer view in mind. And I think that gender is a lens that actually really helps us dig in and understand why both of these things are incredibly important. And so I think to maybe level set, I want to start with what is gender? Because we did in the PrepCom see pushback from states on the concept of gender, and particularly the idea of what is the definition of gender. The ILC, in the draft that they put together, decided, like many of the other grounds within the treaty, race, ethnicity, religion, to not define what gender is. It was a compromise that was made during the Rome Statute negotiations to include a definition of gender. And here the ILC didn't include one. And we did see pushback on the idea of what is the definition of gender. I want to reframe that conversation that we're having here, because I think when we talk about gender competency and why it's important to take a gender competent lens, we are not talking about gender as a definition. We are talking about how gender is a framework and a lens to help us understand atrocity. Gender does not equal sexual violence. Gender does not equal women. Rather, gender helps us understand as a part of the baseline of why and how someone may be targeted. Perpetrators have a gender in mind when they target individuals. Individuals have their own gender identity that informs their experience of atrocity. And it's this lens that really helps us get a fuller picture of what we are talking about. The Yazidi genocide is a really great example of this in the sense that when you break it down by a gender analysis, you see why was it that men and older women were killed in the early days of the genocide? Why was it that women, younger women, women of reproductive age were taken as slaves? They were sexually abused. They were used for domestic labor. This is not just something that tells us that sexual violence occurred, but rather is something that says that the way that men were perceived as threats to ISIS was actually a lens through which they identified the type of harm that they caused. And I think this is why it's so important that we take a gender competent approach, because it helps us understand everyone's lens of what happened in a situation of crimes against humanity. The brilliant Patty Sellers, has really talked about the fact that everyone in humanity has a gender. And if there's a treaty that is meant to prevent crimes against humanity, this is an indispensable lens for us to understand what the task at hand is. So really, I'll go briefly into two aspects of this, and then we'll have time, I think, in the Q&A, hopefully. The first is really the structural approach. Gender, and we saw this in the last 2 weeks in the negotiations of the Commission on the Status of Women, it is a difficult issue to negotiate right now at the United Nations. However, that means that we need to think about how we set the negotiations up for success when it comes to issues of gender, but also broader issues when we think about the types of expertise that's needed at the table. So there's two things that from this perspective that we recommend in the ABILA paper. One is the need to actually ensure that there's gender parity on state delegations. This isn't just a luxury, it's actually something that is an obligation under international law. And for the 189 states parties of CEDAW, CEDAW has made it clear that participation in multilateral negotiations, equity in the participation in multilateral negotiations is a legal obligation for those who belong to CEDAW. And so this is something that we need to take very seriously as we think about how this process is structured next April when decisions are made on the rules of procedure for the conference. There's opportunities to really think about how we set the process up to include this type of gender parity. The second aspect is that parity is not the same as expertise. Gender is a complex issue to understand, and it's really important that experts with this specialized expertise are on state delegations, that they're resourced to be on state delegations. Youssef, you mentioned the capacity needs of smaller delegations. We need to think about how we make this type of expertise available to a broad swath of delegations. One thing that we heard a lot of is these are not issues that are important within our country, or these are not our values. But I've had the extraordinary ability to work with feminists around the world. And I know that in every country, within governments, within civil society, there are those who hold this expertise, and they need to be integrated into these conversations as states formulate their position on this treaty. And so that's important. And the second aspect, which we made a huge stride towards, is really ensuring that civil society has meaningful participation. And I will say, note that the decision on civil society participation actually did make a call out to gender parity in civil society participation. So that's officially within the decision that was actually made by the 6th Committee in January. The second aspect, which is what we often talk about when it comes to gender, is the substance. So how do we think about making the substance of the treaty more gender competent? The place that we start is with definitions, right? And largely we start with crimes of gender-based violence or gender-based harm. And since the Rome Statute was negotiated through jurisprudence, through better structural investigations and understandings, we've seen the types of gendered harms that emerge that go beyond sexual violence and that go beyond what's codified in the Rome Statute. And so within the paper, we recommend kind of a 4-part approach to really thinking about how to approach gender. Correcting fixes. For example, there is a compromise that was made in the definition of forced pregnancy that we actually think needs to be taken out as it relates to national laws relating to pregnancy. We need to close gaps. The failure to codify the slave trade, which has very distinct gendered aspects, is a massive gap in international law of a jus cogens norm that has not been translated into codification. And so there's a paper that recommends the codification of the slave trade in addition to enslavement. We also want to catch up to jurisprudence. So the forced marriage has been recognized by multiple courts as an other inhumane act, as a crime against humanity. And there's power in actually labeling and codifying forced marriage at this point in time. We also see a broader swath of types of gender-based violations. And so we've recommended adding either reproductive violence or deprivations of sexual and reproductive autonomy and integrity, because it really captures the fuller breadth of harm that occurs, including in places like Colombia and Peru, where we've seen forced abortion, forced contraception actually be prosecuted as crimes against humanity related to domestic violations. And I'll also just add that gender competency is not just about gender-based harms, right? I saw some questions in the chat about torture. We can go into the details, but the elimination of the custody and control requirement of the definition of torture is actually incredibly important to more effectively prosecuting the types of gender-based harms that we are talking about. Gender apartheid has been raised, so I will talk about gender apartheid, and we will share a link in the chat that actually looks very specifically at the conversation on gender apartheid at the PrepCom, but gender apartheid really looks at capturing the system of oppression and domination that can occur in places like that occur in places like Afghanistan, where you really see that gender-based discrimination has been institutionalized through laws, policies, and is enforced by agents of the de facto state. And so there are harms that are not being captured. And finally, there are bracketing clauses that we think are really important, especially as we think of future proofing the treaty. The inclusion of a clause on non-discrimination and interpretation in line with human rights, which I know ABILA also has a recommendation on, the inclusion of a human rights monitoring body that can actually help to develop what our understandings are of the provisions of the treaty. And so those are also important provisions that we think are key to making sure that the treaty remains relevant on gender as we go forward. The last thing I'll say is there's also gender competent issues related to issues like modes of liability, including, and I know Leila has written about this, but ensuring that common plan liability is actually included has been essential to effectively prosecuting sexual violence at the international level. And so there's spaces throughout this treaty to render it gender competent. And there is a wealth of feminist advocacy that has already been going on to develop what these ideas are and how states can take them forward. So really, just to conclude, I think, is to say that we need to really step back and ensure that as we think about this treaty, we don't just think about the current moment. We don't let the crisis of the current moment define the ambit of our ambitions. And we actually, starting with the April deadline that states have in front of them, set forward a bold vision for what this treaty needs to include. And the second aspect of it is really that states need to come together and work together on these issues. These are issues of priority across regions. And we've seen that already in the conversations, and how we facilitate those discussions through intersessionals, through further cooperation between the ABILA Study Group, other members of civil society, and states, I think is really the way that we're going to create a treaty that is future-proofed, that holds legitimacy over time, and can really be a tool for justice and accountability for victims.
Thank you so much, Akila. And again, I'm always so impressed listening to all of our panelists at the breadth and depth of their expertise and their commitment to these ideas and to this emerging new treaty. I saw a couple of questions about torture. One of the things I'd just like to add is, yes, the draft currently covers both state and non-state actors, The draft keeps all the context elements that are present in the Rome Statute for the International Criminal Court. And so what that means is for anything to constitute a crime against humanity, we have to have an attack against a civilian population pursuant to a state or organizational policy. And so those will be sort of framing context elements. And I haven't heard a single state actually, or really any member of civil society suggest that those should go away. But what that would mean in the context of torture, which is an enumerated act, as is gender persecution, that so long as those context elements are present, crimes against humanity could potentially be established. So I'll just answer that there. We have a few more minutes for discussion. ABILA kindly gave us 75 minutes. I hope all of you can stay. So I'd like to maybe give the panelists a quick lightning round, a couple minutes each, just to talk about things they may have heard or things they want to go back to based on the conversation we've had thus far. And of course, I'll be monitoring the chat. If you have questions, please do put them in and we can respond to them then. So Olympia, I'll just start with you again, since you've been silent for quite a while now.
Thank you, Leila. I think what strikes me is that we have to persevere, be positive, weather the storm that is currently hitting us, and ensure that this is a future-proof document, because this is for humanity, this is for future generations. And I think I would like to echo both what Tom, Akila, and Chris said from the idea that we need to think of where the gaps are, and we need to try and ensure that we have opportunities in this treaty to fix what the law, because the law has moved on, so it's not stuck in time. And perhaps a plea to Youssef and the states to take up this challenge and be proactive and be progressive. And I know, some states have particular interests and concerns, but use the expertise that is available to promote these new ideas. And I will leave it at that.
Thank you so much. And as you heard from Youssef, states are pretty busy because they're working on 2 other treaty processes. So maybe it's not so terrible that the process is drawn out a couple extra years, because it does give us a little bit more time to really socialize and think about and articulate all of these new ideas. But it also means that we have to keep up the momentum. So I think it cuts a little bit in both directions, doesn't it? Tom, do you want to add anything to your initial remarks?
Sure, I'll just say a couple of things. So first, on the issue of prevention, which Olympia covered in her initial statement, I think it's crucial to emphasize that, first of all, we already have these frameworks for genocide and war crimes in the duty to prevent genocide, the duty to ensure respect for international humanitarian law. We have the duty to ensure respect for international human rights law. But this is really about then codifying this kind of preventive obligation for crimes against humanity and not having it lag behind these other areas of law, particularly in a context where it would be the most updated convention on these issues. And a critical component of that is ensuring that preventive obligations are not territorially limited. So that would be a really problematic way of framing preventive obligations in this context. The second thing just on prevention that I think is important to emphasize is that crimes against humanity includes within it categories of harm that are, by definition, slow in the way in which they inflict harm over time. So apartheid is probably the most obvious example of this. And in those cases, preventive obligations are perhaps especially important because there are many opportunities, even after the harm begins, to engage preventively to ensure that it doesn't continue. And so ensuring that the treaty is responsive to that reality and recognizes that reality is a critical component. And then I agree completely with what Akila was saying in terms of the importance of gender competency. And I think if you apply that to the starvation crimes that I was describing earlier, there are multiple ways in which this manifests. So one of the ways in which starvation harms are distinctive is that they are systematically and severely discriminatory against certain categories of persons. So it's not just that it's indiscriminate harm inflicted on a civilian population, it specifically discriminates against those who are marginalized or who are in particular contexts in which access to clean and safe water, access to food is especially critical. That includes, of course, pregnant women, breastfeeding mothers, children, and it includes persons with disabilities as well. So it's not just about gender competence, it's about competence along a number of different dimensions. But we can't fully understand this criminal category without understanding it through those lenses. So even where it's not necessarily visible in the specific definition, it's critical to understanding why a particular crime is important to codify. And it may be important in terms of how that crime is then defined, in terms of making sure that gaps aren't created in that criminal definition that are then exploited subsequently. And Akila also mentioned the importance of understanding everyone has a gender. So gender-based harm associated with starvation, it can also apply in contexts in which you create insecure humanitarian distribution points where men are then the primary actors who are sent to collect that food and then subject to the harms associated with violence at those distribution points. And we've seen that, of course, in Gaza as well as elsewhere. And so these kinds of phenomena, I think, are really important to understand. And it's about bringing that gender competence to the full spectrum of how we're understanding this treaty. So I'll pause there.
Thank you so much, Tom. And one of the other reasons, and I'll just add this before I turn to Youssef, one of the reasons that it may be particularly important to have specific new categories is that we heard from some delegations during the discussion that they're a little uncomfortable with other inhumane acts as a residual category, because in their legal systems, and remember, this treaty is about implementation in national systems. This is not a vertical mechanism, it's a horizontal mechanism. And so for some states, they really would appreciate more specificity in the treaty itself, because that's very important to them in terms of the legality principle in their legal system. And that's one of the drivers behind enumerating things like starvation or slave trade or forced marriage, et cetera, et cetera. Just had to add that little law professor point there. All right, Youssef, to you now.
Yes, Leila, just building on your very, very last comment, actually. And yes, so it's for national assistance at this, and also the idea would be to promote as well international cooperation. Not only do you need as well more specificity, but you need as well for some delegation this sort of consistency. So to your point on what you're saying about the other, and that's why you're right. Some want to have maybe more specific acts constitute crimes against humanity enumerated. So that was as well to your point. And yeah, I mean, I just wanted to, of course, build on what was said, indeed, and obviously these draft articles were adopted in 2019, and by the time we concluded and elaborated, will be close to a decade later. So obviously, we need to reflect on developments, right, in the international legal landscape and the jurisprudence and the new realities, unfortunately, that have emerged. So this is very much what we've been seeing, not only in the PrepCom, but even in the resumed session of 23 and 24, thinking that overall, these draft articles are a starting point, and definitely we need to add more. We need to discuss new forms of crime. We need to see better ways to provide protection, etc. And one last thing that I would like to mention here that was very interesting in the composition of delegations that we had in the PrepCom, because the resolution 79122 mentioned actually was encouraging delegations to include experts and from their countries. And I've noticed that quite a number of delegations brought experts from their ministries of justice, Department of Justice. So you have prosecutors, etc. And this also is to what you're saying, alluding to what you were saying about this idea of domestic system, but also this whole this criminal law aspect. So also I wanted for those listening that also have judges and prosecutors that will be part of negotiation phase. So just wanted to add that specific point. Thank you.
Thank you so much. And that relates maybe to one of the questions in the chat, which is Fanny Lafontaine. Hi, Fanny. We see can legal clinics help? And in fact, we have had many law students involved in these negotiations as observers, taking notes, assisting. And a couple of legal clinics have been helping out at USC and Cardozo and Washington University and many other universities, I think. And we hope that it'll become more global. And right now, because we're in the United States, it's easier for us to get to New York, but we certainly encourage others to join and to join the fight against impunity. Chris, any comments based on what you've heard?
Sure. So I guess two briefly. The first is really just to to echo what Mr. Hitti had said, which is the value of having this sort of exchange. Exchanges frequently take place between professors and academics, and sometimes with civil society organizations and practitioners. But it's not as frequent that we have the opportunity to learn the perspectives, to benefit from the insights of state representatives. And so for us who are also seeking to prepare material that can inform states in the most effective manner, it's especially valuable to have this opportunity to have this sort of exchange. The second point maybe is just to go back to what I believe Dean Bekou said at the very beginning, which is that the value of the eventual convention won't be solely in its adoption, but in its ultimate effectiveness. And we've heard a lot of discussion about the need to have monitoring mechanisms, the need to have capacity building and other sorts of aspects to ensure that it is effective, not only on adoption and not only on entry into force, but subsequently. And that also goes towards the provisions themselves, having clear provisions that indisputably enunciate what states are responsible to do in order to prevent and to punish crimes against humanity is also essential. We don't want to be in a position where we unintentionally find wiggle room in the various provisions concerning state obligations. And of course, those can arise in negotiations, but if they do, they should be done intentionally rather than to have some sort of vagueness that can be exploited at a later date and that can hinder the ultimate effectiveness of the forthcoming convention. Thanks.
Thank you so much, Chris. Great observations. Akila, we just have a few minutes. Why don't you close us out with some words of wisdom? I will say there's just one comment about, is this really, there's a risk of regression. And remember, the Genocide Convention itself emerges from the ashes of World War II. So when the atrocities are happening is exactly the time that we have to roll up our sleeves and double down. But thank you for the point. Akila, why don't you close us out today, and then I'll just say thank you and we'll be done.
All right. Thanks so much. I'll just respond. I think there's a couple of questions in the chat that really go to some of the heart of the questions that of the issues I was talking about with gender competency. And some of that is formulated by the very real frustrations of feminist advocates in getting meaningful prosecution and accountability for gender-based harms. And that's really the lens through which those of us who are working on the treaty are looking at it as a comprehensive lens. And so I see these questions around where, the framework of torture has been limiting in pursuing gender-based accountability. And I welcome, I think, from a feminist organization perspective, I'll share my email in the chat. We are working on building a broader feminist mobilization to really understand at the different levels where these frustrations are, what are the harms that have been missing, and how we can, as feminist advocates, really think strategically about how this treaty can better advance these. Because, Leila, you've said this a lot. Crimes against humanity is the prototypical crime in most situations of atrocity. And so it really does cover a broad swath of experiences and situations. And so it's really important that our own process, those of us who are working at different levels, are informed by those who are affected by atrocity, who are on the ground trying to seek justice. And so thank you for raising these issues. I will be thinking about them more deeply in terms of what we haven't addressed. I will share my information. Please feel free to reach out. I'm happy to have a conversation really about it. And maybe just to close out to Tom's point on prevention and why this is so important. So today is the first day of school in Afghanistan, and it actually marks the 5th year since girls and women have not been able to go to school beyond 6th grade or university. We are in the midst of a situation of gender apartheid that requires urgent action. And while we don't have a treaty in our hands, it's exactly why it is so important, because it's not just about accountability at the end of the day, 20 years down the line. It's about the mobilization that we need, the framework that we need to actually address these situations in real time. Because if we did have this treaty now, if we did have gender apartheid codified, it would give those extraordinary activists from Afghanistan who are doing so much work a tool to actually call for states to act, because the intergenerational harm of the fact that girls have already been denied being able to go to school for 5th grade cannot be undone. And it will continue to deepen and worsen. And so it's also, to me, it's these real-time experiences that inform why this treaty is so important. And I think why so many of us are engaging to make sure that it really creates an effective framework for prevention and accountability.
Thank you so much. And thank you to the panelists. Thank you to our audience. Thank you, Julia and Freya and the American branch of the International Law Association. We will continue our work. We are all available by email. Well, maybe not Youssef. I don't want to speak for state delegates, but we are all available. And the work of the study group and our continued briefing on this important and super historical process that's taking place at a very challenging moment in international law. We are here for you, and we will be back. Thank you so much for your participation. And with that, I'll close this webinar. Bye-bye, and thank you. Thank you.